Good afternoon, everyone. My name is Brian Darty, and I'm a history professor at Virginia Commonwealth University. I'd like to welcome you all to the last panel of the 2021 Virtual Virginia Forum. I'd like to thank you for taking the time to join us this afternoon. I'd also like to thank the Library of Virginia for its assistance during this important partnership. The Library of Virginia has been a key player in this entire process of putting on the presentations that we've enjoyed over the course of the summer and into the fall, and a key partner with the Virginia Forum in previous years as well. Virginia Forum, as you can see from the screen, is an interdisciplinary conference that meets every year related to Virginia history and Virginia studies. You can obtain more information about the forum at our website or at our Facebook page. In 2020 and 2021, because of COVID, the forum has been participating in an online forum session. But in the spring of 2022, we're very excited to welcome everybody to rejoin us in person here in Richmond, Virginia at the Virginia War Memorial for the 2022 Virginia Forum, the weekend of April 7th and 9th. Today's panel presentation is the last in a series that have taken place over the course of the summer. And we're very fortunate to have three excellent panelists joining us today. The format for today's panel is I'll introduce each of the three panelists and their paper titles. And then we will proceed with the presentations in the order in which they were introduced. While those presentations are taking place, I encourage you to submit questions about the presentations via the Q&A box or the chat box, and we will collate those questions. Once all the three presentations are done, we will ask those questions with as much time left as possible to the three presenters. Thank you very much. Amy Bertsch is an adjunct instructor in the Public History and Historic Preservation Certificate Program at Northern Virginia Community College and specializes in African American and Virginia history. She previously worked in public history at the Office of Historic Alexandria, which operates the City of Alexandria's museums, historic sites, archives, and its archaeology program. Amy has an MA in history from Sam Houston State University and is a frequent participant at the Virginia Forum. Her recent work includes Lost Potters of Loudoun County, Virginia, the Gardner Duncan family, published in the Journal of Early Southern Decorative Arts, and a virtual presentation on researching a photo of enslaved women and children at the National Genealogical Society's annual conference this past spring. Amy's paper is, I Think He's a Girl, Perceptions of Gender Nonconforming African Americans in Jim Crow, Virginia. Our next presenter is Charles Ford. Charles H. Ford is professor of history at Norfolk State University. He also serves as the director of the Quality Enhancement Plan at Norfolk State University. Ford has pursued and published, along with his colleagues, Cassandra Newby Alexander of Norfolk State University and Jeffrey Littlejohn, once of Norfolk State University and now at Sam Houston State University, several projects dealing with the desegregation of public schools and African American civil rights movement in Norfolk, Virginia. Most significantly, Littlejohn and Ford's Elusive Equality, Desegregation and Resegregation in Norfolk's Public Schools was published by the University of Virginia Press in 2012. Littlejohn and Ford's Reconstructing the Old Dominion, Lewis Powell, Stuart Saunders, and the Virginia Industrialization Group, which appeared in the June 2013 issue of the Virginia Magazine of History and Biography, won the William Rochelle Award for the best article in the Virginia Magazine that year. Charles's paper is The Limits of Equality, Family Values Rhetoric in the Case of Bottoms v. Bottoms. Our third presenter is Jeffrey Littlejohn. Dr. Littlejohn serves as professor of history at Sam Houston State University. He completed his undergraduate degree at Belmont University in Nashville, Tennessee, and his MA and PhD at the University of Arkansas. He is the co-author or co-editor of 3 books, Elusive Equality, mentioned previously, The Enemy Within Never Did Without, German and Japanese Prisoners of War at Camp Huntsville, Texas, and The Seed Time, the Work, and the Harvest, New Perspectives on the Black Freedom Struggle in America. Littlejohn has also published numerous articles with his co-author, Charles Ford, including The Cabiness Family Lynching, Race, War, and Memory in Walker County, Texas, Booker T. Washington High School, History, Identity, and Educational Equality in Norfolk, Virginia, and Arthur Morse, School Desegregation and the Making of CBS News. Littlejohn is also an active digital and public historian with projects funded by the National Endowment for the Humanities, the Virginia Foundation for the Humanities, Norfolk State University, Sam Houston State University, Humanities Texas, and other organizations, including Lynching in Texas, East Texas History, his podcast, Living History, and other digital materials related to the Underground Railroad in Virginia, the Brown decision in Norfolk, Virginia, and democracy and diversity in Walker County, Texas. Dr. Littlejohn's paper is The Campaign for Marriage Equality in Virginia. Please join me in welcoming our three presenters.
Thank you so much, Brian, and thanks to the Library of Virginia staff for giving us this wonderful opportunity to discuss some of Virginia's queer history, some really compelling aspects. I'm going to be introducing Hannah Noakes from Northern Virginia and Rufus Emerson from Norfolk, who were both assigned male at birth and were gender nonconforming. Today we think of them perhaps as transgender, but they didn't have that term to describe themselves. So in the case of Noakes, I'll be using her chosen name of Hannah rather than her legal name of Hammond. And I'm going to use female pronouns unless I'm quoting someone else. With Rufus Emerson, I'm going to use neutral pronouns. And again, unless I'm quoting somebody else. A lot of what I've been looking at are news articles that Noakes and Emerson were mentioned in, but I've also studied legal papers and a lot of other records. And I hope to share today are some of the perceptions that others had of Noakes and Emerson, and that to varying degrees, how others perceived them as female and how they portrayed them. Their race is also important in how they're depicted, but also in their circumstances and experiences. So let's go ahead and introduce Hannah Noakes with the next slide. Hannah was born in 1898 in Sterling, Virginia, which is in eastern Loudoun, for those who aren't familiar with the area. And as an adult, she lived just across the border in Fairfax County in the Drainesville community. Like a lot of other Black women in the Jim Crow South, she worked as a domestic servant in the homes of white families. She did laundry, and she took in boarders to make a living. In 1933, she was called as a witness by the prosecution in a high-profile murder case in which Charles Houston was defending the accused. And there's a photo here. This case, Commonwealth versus Crawford, is the one that Houston used to challenge Virginia's all-white juries. And there was extensive media coverage of the trial, both from the courthouse and in the weeks leading up to the case. Now, Hannah wasn't a witness to the actual murder, but the defendant had spent time at her home. He spent the night a day or two before the murders. There was a lot of news coverage on this case. And with another click, we can see some of these headlines. We know from the news reports that she appeared in court, again, called as a witness by the prosecution, and she appeared in court wearing a dress, a hat, a beaded necklace, and a wig. And some of the newspapers, like the Alexandria Gazette and the Washington Post, referred to her as a man in women's clothing or a man who dresses as a woman. And they noted that Noakes's appearance in court, quote, caused a stir and, quote, amused the courtroom. The Post also described Noakes as an eccentric Negro. The Black press was very interested in this case, and also took notice of Hannah Noakes. They paid a lot of attention to her gender identity. And we see that with some of the headlines here, that the Richmond Planet used expressions like fairy and lady man. And the Afro-American called Noakes a red-wigged boy girl, and even used female pronouns in their articles, but did so with quotes. So they wrote that she, and put she in quotes. She talks in a husky masculine voice, wearing a green gown, beads, silk hose, and women's galoshes. Some of the coverage outright mocked her. This passage from the Afro is one that stands out. Her bosom and hips are padded a la Mae West. Sometimes the breast pads fall down to her stomach. And we're going to see this type of focus on women's features again when we talk about Rufus Emerson. Now, during the trial, Houston did not cross-examine Hannah Noakes, but he did question Noakes's nephew. And he asked the young man, "Is Hannah Noakes your aunt or your uncle?" And under oath, the young man answered, "Aunt." Now, we'll go ahead and go forward a few years with the next slide, because really it's just 3 years after the Crawford case that Hannah Noakes is featured in a government publication as a working class success story. The Rural Electrification News highlighted successes of bringing electricity to rural America. And according to this article, one of Hannah's employers signed a note so that Hannah could get her home wired for electricity. Hannah also purchased an electric washing machine. So with these advances, her business of taking in laundry would certainly be more efficient and profitable. And in profiling Hannah, the Rural Electrification News praised her work ethic and her community ties. And with a click, we can look at that and also see her picture. It reads, "Hammond is through the countryside for her industry, honesty, and good nature. Born in the community where she lives, as were generations of her ancestors, she is regarded with affection and respect by her neighbors." And the article also features this wonderful photo of Hannah wearing an apron and mob cap and still doing laundry by hand. And the article identifies her by the name Hammond, but there's nothing in the article or image itself that casts any doubt as to her gender. The Rural Electrification News clearly presented Hannah as a woman. And it also indicated that she was trusted and respected in her community. So next we'll go to our next slide and introduce Rufus Emerson. Rufus Emerson was born in Norfolk in 1922 and worked with their father for many years as a cook in one of the union halls. Emerson sometimes dressed in women's clothing and wore makeup. And there's a record here. Emerson was registering for the wartime draft, and the registrar noted on the draft card under the physical descriptions, and with another click, we can see the full quote, "I think he's a girl." So the registrar, while filling this out, made a point to point that out, that "I think he's a girl." Like Hannah Noakes, Emerson's photo also appeared in a publication. The Norfolk Journal and Guide shared a photo of Emerson and a brief interview as part of a man on the street interview where they were discussing wartime restrictions on driving, of all things. But Emerson also made the news for other reasons, including being arrested multiple times. And according to these newspaper accounts, Rufus Emerson would dress in women's clothing in an effort to attract sailors and then take their money. In 1943, the Virginian Pilot reported that Norfolk police arrested Emerson after one of these offenses. And the paper reported that Emerson's cheeks and lips were rouged, so wearing makeup. Now, Emerson wasn't the only person who took part in this type of activity. There was another article in the Virginian Pilot that indicates that Emerson was one of, quote, 4 young Negroes who allegedly masqueraded as women to lure servicemen into alleys and rob them in Virginia Beach. Well, it's also likely that these sailors reported that they were robbery victims only after discovering Emerson's gender nonconformity. With the next slide, we'll take a look at what happens to Rufus Emerson. In 1952, a police officer in Norfolk targeting vice activity shot and killed Emerson while attempting to arrest them for soliciting for immoral purposes. The Norfolk Journal and Guide, which we see here, in covering Emerson's death, focused on their gender identity and portrayed them as sexually deviant, and repeatedly used terms like pervert and sex pervert. The Journal and Guide's account describes Emerson's death, and with one more click, we should be able to highlight this passage. It indicated that they had an ID documenting their gender. The article stated, and even after he lay dead in South Halls Lane on the night of June 11, his ambition was disclosed by identification he carried, listing him as colored female. The paper also emphasized Emerson's physical appearance, writing, he died as he wished to live, clad in women's attire, pedal pushers, and a blouse, with water-filled balloons strapped to his chest. So like the Afro-Americans' description of Hannah Noakes' breast pads in court, the Journal and Guide reported Rufus Emerson had balloons filled with water in place of breasts. In these accounts from a Black newspaper, Emerson is portrayed as deviant and dangerous. The Virginian Pilot, which had previously reported on Emerson's dressing and appearing as a woman, did not mention Emerson's appearance, clothing, or gender nonconformity when covering Emerson's death. In both Hannah Noakes and Rufus Emerson's cases, their stories are known to us today because they were visible. They were visible in their community and because they happened to make the news. Although their gender nonconformity is what newspapers took note of, we need to remember that they also appeared in publications that did not mention their gender nonconformity at all. Thank you.
Thank you for everyone attending today. And unlike Amy's paper, this paper looks at something that's probably very familiar with everyone. And that is the Bottoms case from the 1990s, which of course we probably all remember, or at least remember some of the particulars from that time. Remember, it began in March 1993, and of course I was a professor at Norfolk State at that time, so I'm part, it's part of a history that I grew up with, or at least was familiar with in Virginia at that time. In the early 90s, gay liberation had come to conservative Virginia. Cultural changes had been made. There had been increased visibility and some acceptance, some cultural acceptance. But of course, the laws and the politics were at least 2 generations behind. And again, that was certainly in the case of the definition of family and what it meant to be a family. In fact, the laws dealing with sodomy and dealing with the whole panoply of laws in the Commonwealth, as they had with racial equality, were some of the most oppressive in the nation. So the laws of Virginia didn't match, of course, its culture. And that was certainly the case here in the Bottoms case. The limits to equality certainly seem to be imposed by traditional Christianity, even though the Bottoms themselves and the judges involved were not particularly evangelical fundamentalists or on the extreme religious right. They all seem to be within the Episcopal or mainstream Protestant spectrum, right, of Christianity. And certainly that part of Christianity had moved to sort of accept gay marriages, even though they didn't officially do so until this century. But those limits imposed by traditional Christianity, perhaps of a different generation in the law, were certainly evident in the tragic case of Sharon Bottoms, who again is a young, newly out, she was in her early 20s. She was sued by her own mother, Sharon Kay, for custody of Sharon's infant son, who was born in 1991, and she was sued in January of 1993 for custody. Sharon Bottoms was in a committed relationship with another woman, April Wade, whereas Kay had been in an off and on relationship with a man for 17 years, and it was off by the time she had sued. She was no longer living with the man, although they were still friends in 1993. And the first court judge, Judge Boyce, William Boyce, ruled against her, and then she appealed it, and it went to the Henrico County Courthouse. And of course, Briefer Parsons, we'll see him in a minute, ruled in favor of Kay, saying very bluntly that Sharon was immoral and unfit and illegal and doing illegal behavior, the sodomy laws, and therefore, solely on that basis, she should not be a parent in Virginia. And so the paper or my presentation looks at this debate, the arguments on both sides, and argues that because the Bottoms defense tended to use the same family rhetoric or try to fight Kay Bottoms and her lawyers on the same rhetoric and the same language of the family values that was very popular in and around that time, that they tended to, they lost the case because of that. They fought on the same level, the same playing ground, and there was just no way within Virginia, within the confines of those judges and their experiences, that fighting on the same level, the same rhetoric, the same word choices and concepts, that they could have won. Now, of course, the equality argument, which lawyers would have used today, could have been used. They chose not to. They chose not to invoke civil rights or other kinds of rights, human rights arguments that could have been used, had been used to fight other forms of oppression. They decided, again, to, because of the conservative nature of Virginia, that this argument or this way would be the best. But as Audre Lorde said, you really can't bring down the master's house using the master's tools. And certainly in this case, that was unfortunate for Sharon and her chances to have custody for her son, Tyler. She just couldn't do it within those confines. So let's go to the next slide. And this, of course, case went back and forth, right? Sharon did win in 1994, only to lose in 1995 in the Supreme Court. Remember, again, it began in juvenile court with Judge Boyce. And April 1993, Judge Boyce ruled for Kay Bottoms against her daughter. And then Sharon appealed it and, of course, lost in Henrico County, Virginia Circuit Court. And then she won her second appeal, this time in the Virginia Court of Appeals. The grandmother regained custody in a 4-3 decision written by Asbury Christian Compton. And then it was remanded back to Judge Boyce to determine visitation and custody, or just the confines of custody, or the parameters. And Sharon argued that she had become a department store clerk. She had a full-time job there. Kay was only a part-time nanny, and she didn't have the financial resources to take care of herself, let alone her grandson. But that was, again, repulsed because they fought over the merits of being a clerk versus being a nanny, and which was the best kind of preparation for being a mother, if you can imagine that. And so again, that kind of argument again was self-defeating, because of course a nanny is take care of the children. Therefore, Kay, the Boyce was persuaded that Kay was a better mother because she had that training. But of course, if you look at Kay herself, she said, well, she failed in educating or in bringing up Sharon as well as she could. And so she admitted that she had problems as a mother in her history. But of course, but Boyce was convinced that because she was so experienced, that she could be the best mother there instead of Sharon. So again, you can see how awful that would be for Sharon Bottoms in her case. And Boyce also went on to criticize Bottoms for trying to have her story as a TV movie of the week, which eventually it did become. although monies didn't go to Sharon. Valerie Bertinelli and I believe Vanessa Redgrave starred in Two Mothers for Zachary on the American Broadcasting Corporation ABC network in 1996. So that came out in that year, but she didn't get any money from it, not that she wanted. And in August 1996, she really gave up her series of formal appeals, but she still tried to get better visitation and also to allow April Wade, her partner, to have visitation. And of course, that began the whole thing that in December of 1992, Kay had said to April that you cannot see Tyler. And that began the whole filing for custody and everything else. The relationship seemed to be the incident, the cause, right? The immediate cause of all of this. So that the relationship between April and Sharon, which seemed to be more stable than Kay's relationship, seemed to be the whole crux for Kay's determination to make sure that Sharon did not have Tyler. I think if Sharon had remained single, then Kay would have been more resigned to the fact that Sharon could bring her up. And of course, Kay could influence Sharon much more if she was single rather than her being independent on her own and also with a partner. So that's kind of interesting as well. This again is the quote from Buford MacArthur Parsons, September 7th, 1993. The mother's conduct is illegal, immoral, and renders her as an unfit parent. And that was the whole crux of the case, that because she was lesbian, apparently, she could not be a parent, or she could not be a good parent at all. And this contrasts with his other quote, his other famous quote, which was in his obituary from 2014. And it states that lawyers should try the cases and judges should stay out of it, that the judges should be like baseball umpires and let the lawyers try the cases. And in that sense, he's going to precedent and saying, well, and the precedent there in Virginia at the time was a case called Roe v. Roe, which had a court take away custody from a father who came out as gay and gave it to a mother who had been ruled earlier as unfit because the mother was not gay and the father was, and that preceded the mother's history of being an unfit parent. And so that determination of homosexuality was just a terrible thing and was awful and overruled everything. That seemed to be his justification for making this statement. So the next one is a quote from Asbury Christian Compton for the 4-3 majority in the case. And again here, while the legal rights of a parent should be respected, those rights may be disregarded, demanded by the interests of the child. The Supreme Court here stressed the moral climate, the social condemnation that Tyler faced if he had a gay mother, considered illegal or criminals by their very nature, by the sodomy laws. There were legitimate factors in denying the mother custody, but they also listed all kinds of other factors that badmouth Sharon as a mother and outweighed them with Kay's liabilities and found that Sharon was less competent than Kay. Now again, you have the family values rhetoric on both sides. Of course, Sharon stressed the biological mother should be the best parent, right? Because the biological mother would be younger, more attuned to the child. Of course, the grandmother had more money, not really sense in this case, but older, more experienced, more insurance, better because she could intervene, and she was concerned for the moral interest of the child, and she was concerned about the child and not herself. Everything's doing for the child, right? Homosexual parents do not inherently hurt their child. That was the whole thing with Sharon, but they really didn't stress that. It was all about the unfit nature of Kay and the enabler of sexual abuse. Apparently, Kay had allowed a man in her for a long time in her house who abused Sharon when she was a teenager. So that might happen again with Tyler, who knows? But that was weighed as well. Now, the lesbian relationship was just would overwhelm everything. Of course, that was the precedent in Roe v. Roe of 1985. But fighting on that, eventually, I think, fighting on that level with the conservative judges of that time, all elite law school grads from either Richmond or Washington Lee, of course, being where Compton went, and being the producer of all those lawyers for official Virginia that upheld Jim Crow for so long, though those kinds of lawyers would not, again, be the kinds of people to be leading advocacy or changes for homosexuals or LGBT people at that time. So again, if you have any questions about this Bottoms case, I've been researching more and more of it. And here's my contact information. Thank you.
Well, thank you to Brian, to Catherine, Ashley, the Library of Virginia, and the Virginia Forum for having this presentation and for all the work they've done in the background to make this possible. It's taken a lot of work, and I want to be sure to thank them. So in February 20, I'm just going to read the first paragraph and then I'm going to talk. But in February 2014, U.S. District Court Judge Arinda Wright Allen issued a landmark decision in the Virginia same-sex marriage case, Bostick v. Schaefer. Drawing on constitutional arguments presented by the American Foundation for Equal Rights, Allen declared that Virginia's 2006 constitutional amendment banning same-sex marriage violated the U.S. Constitution's 14th Amendment Equal Protection Clause. That was in February 2014. The Fourth Circuit Court of Appeals upheld Wright Allen's decision in July 2014, and the U.S. Supreme Court denied certiorari 3 months later, which effectively legalized same-sex marriage in Virginia months before the U.S. Supreme Court's more famous Obergefell v. Hodges decision, which legalized same-sex marriage throughout the United States in June of 2015. This presentation, which is really a starting point, will explore the modern LGBT campaign to legalize same-sex marriage in Virginia. These marriages were performed by ministers in Unitarian, UCC, and metropolitan community churches, among others, before legal sanction was given to such marriages in 2014. I want to pay particular attention to the arguments in support of same-sex marriage, the arguments against same-sex marriage, and the way that culture, politics, and legal changes created a new environment that was supportive of same-sex marriage during the second decade of the 21st century. Now, I have a video here, but actually because of tech issues and everything, I think I'm just going to tell you what it says. I think that will be easier for all of us involved. This is an interview with one of the founders of Lambda Legal, Bill Thom, and he really gives a background about what LGBT laws or anti-LGBT laws were like at the end of the 60s and the beginning of the 70s. So he says, I'm going to quote, and you can watch the video there at your leisure on your own later if you like. In the 1960s, he says, 49 of 50 states outlawed sodomy in one way or another, which was effectively outlawing homosexuality. The American Psychological Association referred to homosexual people as people with mental illness. He says that no state had any law protecting LGBT people from discrimination or violence. Gay bashing was widespread, and he said that did not mean politicians making statements about members of the LGBT community in the press, although that did happen, but that it was an act of violence, that people were beaten and targeted by people who dislike the LGBT community. In addition, he points out, his interview focuses on New York State, and he says that in New York State before Stonewall, that the ABC, the alcohol beverage control laws, prohibited members of the LGBT community from congregating in bars, and that police could raid those bars based on those legal provisions. Virginia had two such laws one of which said that any bar could lose its license or be closed down if, or its license could be revoked if it became a meeting place for drug users, drunks, prostitutes, pimps, panderers, gamblers, or homosexuals. So that was the context that he lays out. I just thought it was a very good overview. Now, so the context for what goes on in Virginia in the campaign for gay marriage begins in the 60s, late 60s, with the Stonewall Uprising and the beginning of a nationwide movement for LGBT rights, not only in marriage law, but anti-sodomy law, changing these ABC rules, and putting in place laws against discrimination in the workplace and other things. So it was a comprehensive type of campaign. Obviously, the one thing that I found most interesting in terms of talking about marriage and the relationship of married couples is that there were very significant cases decided by the Supreme Court between 1965 and 1973, which dealt with privacy. So Griswold v. Connecticut, people are, students today are flabbergasted to find out that before 1965, married couples could not use contraception in the privacy of their own bedrooms. Then you have of course, the famous Loving v. Virginia case, in which the Supreme Court says that Virginia's legal mandates prohibiting interracial marriage violate a fundamental constitutional right of individuals to marry. And of course, that case will be very important later in the arguments for same-sex marriage. And then Roe v. Wade, continuing the privacy argument that was originally introduced in Griswold, that the 14th Amendment due process clause had an inherent protection of privacy, in this case, for mothers, pregnant women, to decide whether they would have an abortion or not. Now, at the same time, these important legal decisions are being made, a important legal organization, Lambda Legal, is founded, and it is going to play a very significant role, of course, in litigating for same-sex marriage rights. Now, this is I apologize for this crazy slide and all the text on it, but I just wanted people to know that in 1975, and this was something I didn't know, and I worked with Charles very closely, and we were talking, and he didn't have a lot of information about this either. So I thought, well, if Charles doesn't know it, that means it's probably not widely known. And so there was, in 1975, Virginia redid its legal code. And in renewing that legal code, it explicitly prohibited same-sex marriage, and it raised the sodomy penalty from 3 to 5 years for individuals who would be arrested on those charges. Well, that new law was challenged in 1975 in a federal court case called Doe v. Commonwealth's Attorneys for the City of Richmond. It was, like many of these cases, which I was also astonished by, it was a very narrow decision. A 2-1 decision could have turned it the other way. And we have Judge Albert Bryan finding for the majority, and he said that sodomy laws in Virginia did not violate the Constitution. And in his decision, he explicitly noted how long sodomy laws had been on the books. In Virginia, that was since May of 1610. He referenced biblical condemnation of homosexuality. And he said specifically that Virginia was not required to show that moral delinquency actually results from homosexuality, only that the conduct is likely to promote moral delinquency. Now, on the other side, Judge Robert Marriage, who many of you obviously are familiar with, I know Brian is because of the work he does in civil rights. Marriage is a famous, justice in a federal court justice in our judge in Virginia. He said he disagreed with the opinion. He said no evidence demonstrated that homosexuality causes society significant harm. He says that the majority decision was enacting or approving a prescription on homosexuality based only on what it called morality and decency. And he wasn't saying, he's saying that's what they're calling it. And he said that was not grounds for a constitutional decision, that in fact, the grounds for the constitutional decision were the rights to privacy and that the decision was wrongly decided. Now, this case was appealed directly to the US Supreme Court from the district court level. And in 2 sentences, the US Supreme Court, by a decision of 6-3, said that the case was rightly decided at the state level. So after 1975, there are 2 major campaigns, one for LGBTQ rights and marriage, and the other, which I say is the religious right. I'm not trying to offend anybody here, but I think conservative, religiously based organizations said that marriage was definitionally a union between a man and a woman. So the definition of marriage itself was about men and women, different sex couples. They highlight Judeo-Christian texts, obviously the Old Testament, Leviticus. And then they talk about pragmatic concerns that if you overturn marriage laws that had been in place for a long time, that there would be all these pragmatic difficulties that people had not anticipated. And so those were the principal arguments. And we see that these arguments are very powerful. For example, Bowers v. Hardwick upheld sodomy laws nationwide. Then the Congress and President Clinton signed DOMA, the Defense of Marriage Act, in 1996, which said no state had to recognize same-sex marriages and that the US federal government would not recognize them. At the same time in Virginia, statutorily in 1997 and 2004, Virginia passed laws that said same-sex marriages would be void and unenforceable. That is, marriages from outside the state of married couples coming here. Then in 2006, Virginia passed a constitutional amendment which prohibited same-sex marriage. And I just put Proposition 8 to kind of compare. The same thing is going on nationwide in this campaign. Meanwhile, on the LGBTQ side, you've got arguments about the 14th Amendment Equal Protection Clause. And if we had more time, I would talk about the liberation versus orientation argument. But I believe, and I was talking to Charles about this yesterday, that there is a very complex argument going on within the legal community of the LGBT movement about how best to argue these cases, much like what we see and what, for example, Brian has talked about in his own work, looking at the NAACP and the campaign against racial segregation. How best do you make these arguments in court? And it's a fascinating discussion. But we see at the state level, Hawaii, Vermont, New Jersey, we see marriage license being issued in San Francisco. And we see that the president of the United States himself, Barack Obama, who had campaigned really not in support of gay marriage, then comes out in support of gay marriage in the middle of his presidency. And that has a big influence. In addition, the US v. Windsor case in 2013, which was about basically what happens when one member of the same-sex couple dies and what happens with the estate in that case, and federal law regarding basically what happened is it was a same-sex couple, 2 women, one of the women died. They had a large estate, she had a large estate, and the federal government tried to tax her partner $363,000, I believe it was, of the state tax. And so she sued in federal court, and DOMA, that portion of DOMA which dealt with that regulation, was overturned by the Supreme Court of the United States. Now, the 3 most important cases that deal with same-sex marriage in Virginia, of course, Lawrence v. Texas, overturning federal sodomy law in 2003. That's a case from Texas where I'm working now, and I have several great friends who are working on that case. But when we talk about same-sex marriage in Virginia. The key case is Bostick v. Schaefer of 2014, which involves these two men, Tim Bostick and Tony London. And I love this case because there they are standing in front of the Walter Hoffman Courthouse, the U.S. District Courthouse in Virginia, where we focus so much of our energies looking at civil rights for African Americans. And they are represented by the American Foundation for Equal Rights and its two principal lawyers, Ted Olson and David Boies, who you probably remember from the famous 2000 election war. They were on opposite sides of that Bush v. Gore, and they came together, of course, to argue in favor of same-sex marriage. Now, as Charles told me, and I later learned through my own research, the Virginia Attorney General, Mark Herring, who had initially opposed same-sex marriage, once he got into office as Attorney General in Virginia, he refused to support a ban on same-sex marriage. And actually, Virginia did not support its own constitutional amendment. Bostick and London won their case, as I've already said, at the district court level. They appealed it, or it was appealed by the state to the circuit court level. They were joined by two lesbian couples, both of whom had children. So it relates to Charles's case with the Bottoms v. Bottoms case. And those two lesbian couples were represented by Lambda Legal and the ACLU. And of course, they, as I already said, they won their case in late 2014. And then the Oberfell v. Hodges case of 2015 nationalized same-sex marriage and said that this was a fundamental right and that it was an equal protection 14th Amendment issue. So I'm still learning a lot about this. I'm fascinated by it. I see a lot of similarities and some obvious differences between the African-American civil rights movement, but I appreciate being a part of this panel and working with my good friends, Amy and Charles, on this work. Thank you.
Thank you, Jeffrey. I don't see any questions submitted into the chat, so I wanted to go ahead and ask a question that might connect a few of your presentations. Charles, Bottoms v. Bottoms seems a bit like a Pyrrhic victory for the social conservatives, and I'm wondering if you could speak a little bit about that, and perhaps Jeffrey might connect that case in the 1990s with the transition that he presents in his remarks toward the present day.
Well, the family values arguments depended upon the personalities and particular situation within the Bottoms family. And of course, Sharon, was not the most perfect person. When she had Tyler, she was quite young, and she wasn't living with a gentleman that the father, who said that Sharon should have the children anyway, or should have Tyler anyway, because she was a better mother between Kay and Sharon. But because of the social conservatives and victory here, based on the way a judge weighing the personalities and particular and emphasizing that lesbianism or homosexuality was the worst sin you could ever have, even worse than child abuse, right? Within Kay's household. That argument was not made. It was tried to be made with these couples who were vetted and selected to have, very upstanding middle class people with a lot of money and a lot of education, and no red flags or skeletons in their closet that could be brought out against them later on. Because I know Tim Bostick and Tony London personally, and they're very, very well-connected people in the community. And unlike Sharon, who was not well-connected, and Kay, you would think she was well-connected. She wasn't. She was, living in a mobile home in Spotsylvania County. But compared to Sharon, she was considered more stable. And the nanny was better than a department store clerk, right? And those particular things, you couldn't do that with these couples that were chosen. Tim Bostick was an English professor at the time of Old Dominion, and Tony London was Mr. Real Estate of Norfolk, right? So again, it's based on class. social class, I think, really determined their, because again, this is not just criminality, because homosexuality within the early 20th century was associated with criminality and marginality and very, sketchy people. These people were not sketchy at all, according to the conservative standards of the family values people of Virginia.
Thank you, Charles. And Jeffrey, just for the last minute or two, could you connect some of the broader social and cultural trends that were taking place in the United States with the transition in the courts that you see in your presentation?
Well, I can try, and Amy, you and Charles chime in here and help me out. But the thing that strikes me is how narrow these victories are and how narrow the losses were. So, you take the Bottoms v. Bottoms case in 96. I mean, in 2006, when they passed the constitutional amendment in Virginia, it's by a very narrow margin in the public vote. The legislature. Yeah, the legislature passes it, but the public vote is narrow, and the Supreme Court decisions are very narrow. So, I see it, and y'all correct me if I'm wrong or add in and chime in as you see fit, but I see it as convincing a small percentage of the middle class population in Virginia and other areas that this is a civil rights issue. It's an equal protection issue. It's a right for people to determine their own, their own values, their own family, their who they love. And I think they use that language from Loving Virginia. This is a fundamental right. And they showed in court that people were being economically harmed. They were being parentally harmed, as the children were being harmed by being taken away. And then the culture more generally obviously became much more accepting between 96 and 2006. But let me pass it to Charles and Amy and see what they think too.
I always thought that the effort to actually make it illegal to go outright and enact a law that forbade gay marriage in Virginia was in response to, efforts we saw. I'll say this coming out of Alexandria, legislative packages that went to the General Assembly in the late 90s, where there were efforts to introduce protections, just basic human rights protections across the state, and the retaliation or resentment or reaction from the rest of the Commonwealth. And that not only were those requests defeated, really, introduced in the General Assembly and didn't go anywhere, but, just 3, 4, 5 years later, there's this great effort to make it outright illegal. And so I don't know that it was surprising that that law was enacted, but I do think it was a little bit surprising how, what change we've seen in the past 10 or 15 years, how quickly it turned back. Does that make sense?
Well,
absolutely.
One of the arguments that Charles really advances, and other people, when we're looking at, for instance, school desegregation and massive resistance, is that the conservatives overplayed their hand.
They overplayed their hand.
These very harsh laws and explicit discrimination open the door, I think, in a way.
Explicit discrimination against, by the time of the Boston case, of middle class or upper middle class people, that this amorphous middle, moving them over to the side of equality, I think persuaded, because the Bottoms case, again, attracted national attention, was on all the national news channels. Connie Chung had an interview, and all kinds of other people in that era. Of course, the movie, right? But people did not identify with Sharon, though, I don't think, completely, at least in Virginia, the Episcopal, the establishment, right? Moving those people over to this equality side, and that was key. Moving someone like Mark Herring, over to the side of equality. I think that changed it. Make it more acceptable.
Thank you. And on behalf of the Virginia Forum, please join me in thanking all three of our panelists today for an excellent afternoon discussion. The Virginia Forum hopes to see you all in person in April 2022 at the Virginia War Memorial in Richmond, Virginia. Please see our Facebook page or website for additional information. Thank you again to the Library of Virginia for hosting this series and all of you for participating. Excellent discussion. Good afternoon, everyone.